I'm here to talk about why there's no such thing as a citizen journalist. The First Amendment states that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. So in the Constitution, the Founding Fathers clearly separated freedom of speech and freedom of the press. And common sense would dictate that the Founding Fathers knew that those are two separate entities. So that's what I'm here to talk about today. And more specifically, what is defined as press. For all of you Constitution humpers, when is someone considered press under the Constitution? The California Ninth Circuit of Appeals case, Schoen v. Schoen, says, quote, "The critical question for deciding whether a person may invoke the journalist's privilege is whether she is gathering news for dissemination to the public. The test is whether the person seeking to invoke the privilege had the intent to use material sought, gathered, or received to disseminate information to the public, and whether such intent existed at the inception of the news gathering process. If both conditions are satisfied, then the privilege may be invoked." I'm just going to pause right there, because what that means is to be press, you have to have the initial intention of objectively presenting information to the public. Now, there are certain people around here who say they are press, and these are people who don't publish stories, don't write articles, don't do any actual journalism. They say they're press, and they aim their camera at you, and they post pictures of you, not to disseminate information to the public, but to intimidate and to harass. And that is the difference. I'll continue. That test only allows actual journalists to defend their right to protect their sources. This standard likely also means that someone walking into court trying to defend their criminal actions based on the fact that they were a journalist is unlikely to fly if they do not actually engage in real journalism. A case in New York, Chevron Corp vs. Berlinger, says that in addition to the intent to gather information, the journalist should be independent and not someone reporting on behalf of a directly interested party. Houchins vs. County of Alameda was a case involving the media trying to get access to an off-limits area of a local jail. And they said that a journalist is not entitled to access information not available to the ordinary public, even if that information is under government control. What all of this means is that psycho election denier grandma can't barge into our elections office and demand VIP treatment. This is case law, and it means you cannot simply say you're press and barge in to a county government building and demand to take photos of anything you want, demand to go into areas that you aren't allowed to go in, and act like you have some sort of unfettered access to the entire building because you decided to print out a little piece of paper that says press on it. Sorry, there's already checks and balances in place for that. And the people that have done things like that so far, guess what? You've broken the law. I don't even have to say your names, because everyone watching this video is already going to know who you are. And hopefully, law enforcement sees this too.